Hello everyone, and a very warm welcome to this ICAS webinar on employment status for tax purposes, policy and practice. Today I'm going to give an overview of employment status for tax purposes and explain what ICAS is doing in the background on the tax policy making front to try to reach a better solution. For those who don't know me, my name is Justine Riccomini. And I am the head of tax at ICAS for employment taxes and devolved taxes. I represent ICAS on the employment taxes front at several key HMRC policy forums, which I co-chair, including HMRC's Employment and Payroll Group, the Employment Status and Intermediaries Forum, and the Construction Forum, as well as the Share Schemes Forum. So before we begin then, just a few housekeeping matters to remind you of. You can submit questions at any time through the Q&A facility, which can be accessed at the top of the screen. Questions can be submitted anonymously, and we'll be saving all the questions until the end of the webinar for the live Q&A session. Please also join the conversation today through the chat box accessed at the top of the screen. This allows you to comment and discuss with fellow attendees on matters covered by the webinar. We're of course recording this webinar and we'll make it available on demand for viewing afterwards in case you want to refer back to it or share it with others. The slides will be available on the events page on the ICAS website under the events listing. I look forward to receiving your questions throughout the course of the webinar, and I will try to get to as many of them as possible. There's a huge amount to get through though, so I'll get straight into the detail of today's webinar. Now, as you can see, there's a number of points to run through today. And so I shall move straight on to the next slide. Here we go. So, employment status in the UK. Employment status is a very complex matter. It should never be underestimated. It's always been a complex matter in the UK, actually, but in the years leading up to 1996, it could probably be said that it was a bit simpler than it is at the moment. The main stumbling blocks are, well, I've listed them there below, actually. They're commonly encountered by, employers, individuals and agents, just because of the various bits of legislation that all feed into it. And that is also complicated by the decisions that come out of the courts. The main misunderstandings are around what are the terms that are used to look at employment status. Agents, employers and individuals tend sometimes to make assumptions and don't have all the facts to hand. One thing that people do definitely fall foul of is to try to either consciously or unconsciously make the role fit the preferred status rather than actually just standing back and looking at the whole picture. And also, as an agent, it's very, very important that you are told, if you're trying to help somebody to make a decision on employment status, to receive the whole truth and the whole fact pattern about what's actually happening and what are exactly the terms of the engagement. Another big mistake that people make is not to seek expert advice, and also to try and do things too quickly and to miss things. And that's a common problem, because when you take somebody on, you want them to start work immediately. You want them to get on with the job, and you want to start paying them. So sometimes things are done a little bit too quickly and attention to detail can be missed. Now, I did mention about 1996 at the top of this slide, and the reason I mentioned 1996 was because that was when worker status was first brought in, which complicated matters somewhat from an employment law perspective. So really, I think we can look at that in a second and move on to the next slide. So employment law, I'll go through a few things on employment law first because it's important to understand both the employment law side and the tax side if you're going to make any kind of decisions about employment status whatsoever and help clients with those decisions. So in terms of the employment legislation side, the Department for Business and Trade, the DBT, which used to be BEIS, and prior to that it was the Department for Trade and Industry, etc., etc. So all the legislation concerning itself with employment law is contained within the Employment Act primarily, and lots of other subsidiary pieces of legislation, such as the Employment Rights Act. And then there is a supplement to that, which is the Employment Tribunal case law and the Employment Appeal Tribunal. And precedents on that also are taken into account by the courts, and therefore they should be taken into account by tax professionals when looking at employment status for tax purposes, because obviously whilst the legislation isn't the same, it's very similar, and the reasoning and the fact finding behind it can often help one side or the other. Whether you're looking at employment law or you're looking at employment tax, you can actually see a pattern emerging if you look at both sides of it. So it does help. In employment law, of course, as I said, since 1996, there are three statuses: employed, self-employed, and worker status. And the term worker is very unhelpful, especially seeing as in everyday language, the term worker is a word. It's just an ordinary word which can appear in discussions where you're discussing individuals or groups of individuals. They could be employed or self-employed because they are literally carrying out work. So just to give you an example of that and why it throws a spanner in the works, the Cambridge Dictionary defines a worker as somebody who works in a particular job. So that could be skilled or unskilled, or works in a particular way, such as, they're a good worker, a bad worker, tireless worker, etc. So it can also mean someone who works for a company or an organisation as an employee, but doesn't have a powerful position. So they might be a blue collar worker as opposed to somebody who works in one of the offices in a management role, for example. So by contrast then, for employment law purposes, a worker is actually defined in law by Section 233 of the Employment Rights Act 1996, and they are an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment or any other contract, whether expressed or implied. And I'll let you read the rest of that bit. But essentially, that is how a worker is defined for employment law purposes. So we have to make sure that we stick to that definition and refer back to it all the time if we're referring to worker in the employment law sense. So just to continue with the employment law front, ICAS tells us that someone is likely to be legally classified as a worker if most of the things in this list apply. So in other words, their work for the organisation is a bit more casual. So they might not have a particularly structured day or a structured role, and they might not have a regular working pattern. So they could be on a 0 hours contract, for example, and they're usually required to personally undertake the work. They can't substitute someone else or actually, farm the work out to a third party. They're not offered regular, or guaranteed hours by the employer. So if that's the case, think of them as a worker. And they've got very little obligation to make themselves available for work, but they should do the work that they've actually agreed to undertake. So if most of these things don't apply, somebody's more likely to be an employee or self-employed as opposed to being a worker. So the worker status could be said to fall between employed and self-employed status. So workers have some employment rights, but not as many as employees, and they've got a more flexible arrangement, but with fewer statutory rights. And workers are sometimes referred to in the legislation as Lim B workers. So if you've heard that phrase used before and you've got no idea what it means or where it's come from, it comes from the Employment Rights Act 1996. But essentially, if somebody refers to a Lim B worker, they're basically talking about somebody who falls into the above bullet points. So let's think about what workers might be entitled to. So workers, as opposed to employees, are entitled to a written statement of employment particulars, which has to outline their job rights and responsibilities. They're entitled to national minimum wage if the role that they carry out qualifies for national minimum wage, because let's remember that not every single worker in the UK qualifies for national minimum wage. There are some roles that fall outside of that because it depends on the kind of work or whether that labour that they are providing is actually classified as work for national minimum wage purposes. They're entitled to paid holiday, pay slips, protection from whistleblowing, and protection against discrimination as well, and protection from less favourable treatment for working part-time. So workers are not usually entitled to a minimum notice period, for example, if their employment is ending or if the employer is dismissing them. They're not usually entitled to any protections against unfair dismissal or to make statutory flexible working requests from day one, or indeed time off for dependents or statutory redundancy pay. So that gives us a little bit of a insight into the difference between a worker and an employee. So let's have a think about employment taxes then. So the term employment taxes, I just want to stress, is a very wide-ranging term for a host of different pieces of legislation which cover aspects of employment and working arrangements, such as anything from payroll through to national minimum wage, national insurance contributions, pension arrangements, anything to do with benefits in kind, company cars, that sort of thing, share schemes, working time, etc., and termination payments. But it also covers the construction industry scheme and optional remuneration arrangements as well. So I've just named a few there, but there are lots and lots of different pieces of legislation which are classified as employment taxes under that umbrella. So the employment status legislation for tax purposes is unfortunately non-existent, really, because there is nothing set down in legislation. So employment status for tax purposes has never been codified. So all we have to do is to look at whether, somebody's status is determined by looking at employment tax case precedents, HMRC internal guidance. That's where we have to look for the answers that we're looking for. Unfortunately, because it's never been codified, we can't just turn to legislation and say, well, if you do A, B, and C, you're an employee, and if you do D, E, and F, you're self-employed. But fortunately, employment tax status for employment tax purposes is not complicated by the worker status. We either have somebody being employed or self-employed for employment tax purposes. So that in itself is slightly simpler than the employment law side of things, but we always have to refer to case precedent to see where we are and what the judiciary is currently looking at and how they are assessing and analysing the fact pattern to see whether somebody is employed or self-employed. And that's why it's really important when you are an employment taxes practitioner to look at case precedent on a regular basis to see what's changed and what the new approach is, if there is a new approach, or are the judges still going back to the standard case precedents for employment status? What should we be following when we're looking at this and advising clients? So there's some supplementary legislative provisions which are set out at Part 2 of ITPA 2003, and they are chapters 7, 8, 9 and 10. I'll go through those shortly. HMRC has, of course, its own guidance in the form of their own employment status manual, which is on gov.uk. And there's a status determination tool, which is known as Check Employment Status for Tax, or the CEST tool. Now, there is varying different opinions out there on whether the CEST tool is fit for purpose or whether it isn't. Many people choose to use it, many people stay away from it. The one thing about it is that the CEST tool, if you do an analysis there on and you go through the questions and you're given a result at the end, HMRC say that they are prepared to stand by the result of that tool, as long as obviously the facts that are put into the tool in the first place are actually correct and the employer can stand by them. So let's have a little look at the case law situation then. So there's one outstanding case that goes back to 1968, which deals with employment status, and that's the very well-known case of ready mix concrete. And the judge in that case was McKenna. So he issued this decision, which contained the wording below, which I will let you read at your leisure. But essentially, he decided that he was going to set out what a contract of service, i.e. an employment contract, would actually be made up of. Now, that case has been constantly referred to ever since. This decision is, very, very frequently referred to by other judges in the courts in all subsequent employment status disputes for tax purposes, and if you'll find it in 99% of the case decisions that come out. But essentially what McKenna was actually saying was that a contract of service exists if there are a couple of different factors within there. But one thing that he absolutely was clear on, and I'll tell you about another case that came out a little bit later on, but one thing that he was very clear on was that you can't just cherry pick the different factors that you want to look at. You have to look at them all across the board and make a decision on balance. So he says that there should be mutuality of obligation, there should be an element of control, there should be an element of direction, etc., etc. And the whole element of the relationship between the parties has to be one of essentially a sort of master-servant relationship, to use that sort of reasonably old-fashioned language. But that's what he really was stressing, was that, you know, you can't just hang your hat on just mutuality of obligation, because mutuality of obligation, it sounds like a complex term, but actually what it really means is that somebody's offered work, somebody's accepted work, and somebody's agreed, and the two parties have agreed what the person is going to be paid for doing that work personally. So that is mutuality of obligation, but that can exist in a self-employed context as well as an employed one. So mutuality of obligation is good and it needs to be present, but it also has to be accompanied by other factors, such as a lack of independence, a certain amount of control, this, that, and the other. So there's lots of different things that come into it. So that is basically about what the ready mixed concrete case was about. Now, I mentioned earlier on that there is a set of legislation, having said that there's nothing in law that deals with employment status. There is some legislation which covers intermediaries, and that's the provision of work through an intermediary, which is otherwise known, or historically otherwise known, as the IR35 legislation. But essentially, it's called the intermediaries legislation if we're talking about it in proper terms. So Part 2 of ITPA 2003, chapters 7, 8, 9 and 10 are known as the intermediaries legislation. And I'd encourage you to have a look at it, have a read of it. These legislative provisions have evolved since the 1999-2000 tax year. And what happened was there was a proliferation of alternative working arrangements, such as working through a limited company or a limited liability partnership, which is otherwise known as an intermediary, or perhaps an agency or a managed service company, or even via an umbrella company. So these legislative provisions have evolved over time since 1999-2000. To try to cover off these areas so that people have had to be roped in so that they and potentially their employer, if they're deemed to be employed, were it not for the existence of the intermediary that they're invoicing through, they would be classified as an employee. So basically, you know, the rules tie in with, they must tie in with all the other aspects of employment taxes legislation, but they also do, some of the aspects of the legislation are trumped by these provisions in the intermediaries legislation. In other words, they must be considered before any other aspects of the taxes legislation. I'll explain that in more detail in a second. So what I'm trying to do in terms of the intermediaries legislation is to simplify what seems to be an extremely complicated matter. If you take it back, if you strip it right back, it's not that complicated in terms of the intermediaries legislation, but you just need to bear a few simple points in mind first. So the first thing that you always have to ask is, when you're looking at employment status, is number one, is the individual working as a sole trader? And if they're working as a sole trader, are they employed or self-employed for tax purposes? So looking at that question as a standalone question, that is when you need to make some status decisions about whether they're employed or self-employed. You can do that by using, you know, commercial software. You can use the CES tool. You can do a fact-finding mission and look at the case law and the guidance and everything else and make that decision there and then without needing to take any of the intermediaries legislation provisions into account, because the individual is an individual. They're a sole trader, or they're an individual working as an employee. So that's a simple question: employed or self-employed. Then, if it's not that, you move on to the next one, which is the individual working through a limited company, partnership, or LLP? And if that's the case, you need to go to number 3, which is to consider whether the intermediaries legislation should apply at this stage. So would they be an employee of the engager if the intermediary company or partnership wasn't standing in the way? And if that's the case, then you need to look at the intermediaries legislation. So where do you find the intermediaries legislation? Well, basically, you're looking at Chapter 7, Chapter 8, Chapter 9 and Chapter 10 of Part 2 of ITPA. Chapter 7, in a nutshell, is the agency rules. So where Chapter 7 applies, the agency is treated as the worker's employer and has tax and NIC withholding obligations. Chapter 8 is what's known as the IR35 rules. So where that chapter applies, private sector clients are supplied with work by an intermediary, usually a personal service company or PSC as it's known, and the PSC decides if IR35 applies to them. So from 6th of April 2021, Chapter 8 only applies where the services are provided to private sector clients that are small, and that's in accordance with the Companies Act, or have no UK connection. So prior to 6th of April 2021, it didn't matter whether the services were provided to a small, medium or large entity. But after April 2021, it's only for small entities. So Chapter 9 is the managed service company rules. So where Chapter 9 applies, the intermediary providing the labour is classified as a managed service company, and the definitions of managed service companies are within that piece of legislation. And it's worth noting at this stage that Chapter 9 trumps Chapter 8. So if you find that the provider of the labour is a managed service company, you can't apply Chapter 8 to it. And Chapter 10 of Part 2 is the off-payroll working rules. So from April 2017, a public sector body must apply the rules to the intermediaries supplying worker services. And from the 6th of April 2021, it applies where the work is provided to medium and large UK connected private sector clients. And it's the engager, for the avoidance of doubt, who decides if the off-payroll working rules apply, not the individual or the intermediary. So, and one final point on this slide to remember is that the intermediaries legislation trumps the construction industry scheme legislation. So whatever clients may tell you, and believe me, I've had quite a few debates, shall we say, with clients over whether the construction industry scheme legislation comes first or second. But actually, if you are looking at the provision of services through intermediaries, you must look at this in precedence over the construction industry scheme legislation. So let me just touch on the CEST tool then and HMRC guidance. So the first thing to note about this is that the CEST tool must be used to determine employment status for tax only. It's nothing to do with employment legislation, because HMRC has written and governs the CEST tool, whereas the Department for Business and Trade governs employment legislation. So it's like never the twain shall meet, basically. So the CES tool comes from around the millennium years. So HMRC used to use a paper-based questionnaire, which I recall when I was an inspector of taxes back in the early 90s. We formulated a paper-based questionnaire to determine employment status. And it was kind of a development that came from that. That was where it evolved from. So employers said that they would prefer to have access to an interactive tool which would help them to assess employment status as quickly and efficiently as possible. I mentioned earlier that people, need to make these decisions quickly. For example, if you're on a construction site or some other kind of if you're in a hospital and you need to recruit people quickly to a role, then obviously you can't dally. You need to make these decisions fairly quickly. So some kind of interactive tool was something that employers were asking for. So employers then are able to obtain a decision which HMRC have said that they would honour based on the facts supplied at the time of completing the tool. And obviously they caveated that with by saying that, should the facts not match the reality, HMRC would then not honour the decision. But it's extremely difficult to produce a tool. And, HMRC have done a stellar job, to be honest, in trying to provide something like this, which can determine employment status without actually considering a massive, great big list of fact-finding questions. And of course, every case is different. So even if jobs are looking similar, there might be something within one job compared to another job that is slightly different and puts a different twist on it. So it's good to look at the employment status manual as well. But there's also lots and lots of other guidance available. There's the subscription-based guidance such as Tolley's or Kroner, for example. It's not just it's about taxation. That we're trying to get to the bottom of. We're not trying to get to the bottom of employment rights, although employers guaranteed will be faced when they're engaging somebody with deciding whether they are going along with employment legislation as it's set down or not. And, how dangerous is it for them to go against that? Will they end up facing an employment tribunal or whatever? So really, you need to consider employment legislation with employment tax in tandem. And obviously, there's the question of potential sort of modern slavery, exploitation of immigrants, low-paid workers, etc., to consider as well. So you can't forget about those issues, even though we are actually just looking at the tax position for the purposes of this particular webinar. There are also lots of other things to consider in terms of whether somebody's employed or self-employed. And that is that, employees, if a decision is made that somebody is an employee, they must be enrolled from day one of the employment into a pension scheme, unless they have decided to opt out. The working time regulations must be adhered to. National minimum wage must be paid to all those who qualify for it, and there is an automatic right to request flexible working from day one across the UK. That's slightly different in Northern Ireland, just in case you're based there. But just because an employer might not wish to have those responsibilities doesn't mean to say they can just recruit everybody as self-employed. It doesn't work like that. So let's think about what is the new government saying about employment status. As you know, we had the general election in July, and the new government of the day has made a few statements about employment status. So in terms of my role in policy, this is quite an interesting thing to study because it's giving us a few insights into what might happen going forward. They have a plan to make work pay, which sets out a reform agenda. It targets things like boosting worker protection, ensuring fair pay, modernising workplace practices. So they might revolutionise the working arrangements, indeed, if they manage to implement these practices across sectors. And it seems as if they want to achieve these revisions in a very short space of time. They've talked about doing it within the first 100 days of the new government. So we're all waiting around to see what is actually going to happen next. They're actually talking about potentially merging together the employee and worker categories for employment law purposes. So given that we now know we've got three statuses for employment law since 1998, will we be returning to a pre-1998 situation for employment law? We don't really know what is going to happen. We don't have really any indicators at the moment, but it might significantly extend some vital rights to the people who are now classified as workers. We'll just have to sort of wait and see what happens. But obviously, none of that could be achieved without unpicking lots and lots of legal precedents. There's lots of case law on it where people have been classified as workers in certain roles. So we'd need to look at all of that and see what the outcome of it may be. So the proposals around a single worker status, I would say it's not all doom and gloom, because at the end of the day, it might provide a bit more stability and certainty and possibly some more clarity. We can but hope. Labour are also proposing to abolish the 2-year qualifying period for a full suite of employment rights, which include things like parental leave and unfair dismissal claims. So that may indeed result in aligning UK models with European models, which seem to have evolved slightly more quickly than our model, probably due to all the delays caused by Brexit, etc., I have to say. But, it sounds good. However, an unintended consequence could be that there might be an increase in employment tribunal claims unless something could be mandated to, as a sort of intervention to stop everybody just from piling into the employment tribunal, which is, could be something like alternative dispute resolution, could be made mandatory, for example. And also the involvement of trade unions in the workplace has been in steady decline since the 1970s, as we know. But it may be that there's some sort of shoots of knowledge around it at the moment that Labour are looking to sort of try and unpick that and reinvigorate the union movement a little bit. So we'll just have to see what happens there. So what is ICAS doing in the background about employment status? Well, in 2018, which, let's face it, is 6 years ago now, we set out a series of points in relation to employment status decision making and explained why it's not fit for purpose. And despite asking many times over successive years for the UK government to provide its response to that consultation and then consult further, nothing has since been done, which is quite frustrating. So many of you will know that ICAS advocates for tax simplicity across all taxes. It's clear that the current situation is just so complex, burdensome, very difficult to navigate. It could be considered a barrier to doing business, and it's certainly detrimental to a flexible labour market. We get representations from members and their clients all the time about that particular aspect of it. So it's clear that something else needs to be done. So in an attempt to tackle it, this summer I set up a consultative committee called the Employment Status Consultative Committee. It's a collective of expert representatives from a number of different professional, representative and industry bodies. And we're hoping to work with the UK government to consider the whole of employment status and consider how it might be reconfigured and look at it in a different way. So we'd like to make it, future-proof, workable, viable, easier, simpler. Let's get down to brass tacks and try and maybe, look at it from this angle instead of that angle, for example, and see what we can come up with. It's a little bit like searching for the Holy Grail, as one of our members said, but, you've got to try. We have to try and find a better solution. So we've written to the Exchequer Secretary to the Treasury to ask for a meeting. You can see a copy of that online on the ICAS website. There's a link to it in the slide. And also the latest case to be decided on employment status was issued by the Supreme Court on the 16th of September 2024, last week, in other words. Unfortunately, that case, we were expecting the Supreme Court to really make quite a lot of significant clarifications in terms of things like mutuality of obligation. That wasn't really forthcoming. The Supreme Court made lots of references back to the famous ready-mix concrete case, as well as many other case precedents. And then remitted the case back to the first tier tribunal to reconsider its original decision. So we'll just have to see what that decision is. But the Supreme Court guided the first tier tribunal in its decision to say that the workers or that it was Professional Game Match Officials Limited versus HMRC, and that they're all professional referees, football referees, and they said that the fact pattern was consistent with an employment. So we'll just have to see what the first tier tribunal actually come back with. But that doesn't really take us any further forward in terms of how difficult it is to determine employment status. We're not really, we haven't moved at all. Everything's basically still the same. So without moves from the government and without some kind of massive change taking place, all the slides that I've just been through still apply and will continue to apply until somebody tells us to look at it in a different way. So I'm just going to quickly run through this slide about how should employers and agents approach employment status. So really the strategies that need to be adopted are to, if you are an agent and you're speaking to clients, it's not always possible to tell people immediately whether somebody is employed or self-employed for tax purposes. In some cases, it's absolutely obvious. In some cases, there's a lot of grey areas. But the decision, unfortunately, can't always be made quickly. So you need to manage people's expectations on that. There's a tendency to rush employment status decisions because of the need to recruit somebody yesterday, as I've said before. So planning is key. Recruitment is obviously necessary. We need to have conversations, honest conversations with clients about how to classify these people and make sure everybody's comfortable with the decision-making process, because at the end of the day, you will have the employee or the worker or the self-employed person to answer to if they disagree with your status decision. And potentially you could end up in court. You could end up being challenged through the employment, through the tax tribunals, because they've challenged it in that way, or they could decide to go to an employment tribunal, or they might decide to do both. So obviously, all the considerations that need to be taken into account, including, sticking to national minimum wage. If you get employment status wrong, it could be the case that you've breached national minimum wage rules, and we know how punitive they are when it comes to compliance, working time regulations, etc. The days of slapdash recruitment are long gone, as I've said in the slide. So that is just some things to consider there, to be careful about it all. And obviously, it goes without saying, ICAS and many other professional bodies subscribe to professional conduct in relation to taxation. So it's very important to make sure that as an advisor, you're not advising on something that you're not particularly an expert on. It's better to get an expert in and make sure that they are obtaining all the facts and giving the right kind of advice at the right time. So, just make sure that as professionals that, your backs are covered and you're adhering to professional conduct in relation to taxation. So, with all of that said, I'm going to move on to the Q&A. So I'm just looking at my questions here. I've got one question in the box at the moment, which says, what are the consequences of getting employment status wrong? Well, just to answer that question then, the consequences of getting employment status wrong are basically that you may well have to answer questions from HMRC compliance officers. You may have to answer questions from national minimum wage officers. You might end up falling foul of employment legislation. There are several different areas where you can come a cropper with getting it wrong. So it's good not to be complacent about these things, and make sure that if you are helping a client to review the employment status of any individuals, whether they're invoicing through limited companies or partnerships, or whether they're just working as individuals, that you get that status right, and more importantly, that you can back it up with robust decision-making processes. So have an audit trail of everything that you've discussed, everything that you've covered off, and everything that you've decided, so that you can actually justify your decision. So I'm just looking at the Q&A to see if there are any more questions. It's just slightly delayed there. I've got a question from, let me see if I've got a question here. Is it necessary to do an employment status assessment for every individual, or can you group people and do it like that? For example, in a particular sector, you might have people doing similar roles. Well, HMRC's guidance, which I happen to agree with, is that blanket decisions can be a bit dangerous. And the only reason I would turn to a blanket decision would be if, for example, you're taking on 20 people to do exactly the same role, and you're maybe setting up a new, I don't know, a telephone helpline, for example. All of those people are being paid under the same terms and conditions. There is absolutely no difference between those roles whatsoever. If there's even one difference in the roles, then I would say that you need to do individual assessments, because the fact pattern has to be clear and objective. So you can't just try and cut corners by doing blanket assessments. HMRC don't tend to accept them, especially if they can pick holes in it later on. I've got a question here. If a construction worker has been employed for 5 years, or an employee for 5 years, then is informed he will have to change over to self-employed by the employer, what are his rights? Okay, so this is from Mandy. So thanks, Mandy. I think that if you've got somebody who has accrued a set of employment rights, which they will do if they've been employed by an employer for more than 2 years, then I think it's up to the individual to take that up with their employer, depending on whether they actually want to become self-employed and work through a limited company, or whether they want to remain as an employee. We've got to check first of all, of course, that the terms and conditions of the role are actually going to remain the same, or will they be changed? Is there a reason for wanting to just change them? You know, if they leave on a Friday as an employee and come back on a Monday as working through an intermediary company, has something changed? Has there been an operative reason for that? Is there a viable excuse by the engager or previous employer, as they're now known, as to whether that person should be treated in a different way? And it really depends on whether that decision can be fully justified or not. And if the individual doesn't feel comfortable with that, then they would obviously need to try and challenge that. It's very difficult for a lot of individuals to challenge these decisions because in many, many cases, the power balance is a bit skewed in favour of the engager or employer, because they're the one that are paying the salary or the fees or the invoices, as the case may be. So actually, it might be a difficult conversation, and it may be that the person has to look for work elsewhere potentially instead. But it's something that I would recommend. If somebody finds themselves in that situation, they can always go and see an employment lawyer or potentially a union rep, or go to the Citizens Advice Bureau, or get advice from a tax advisor or an employment lawyer on that matter. And there are many tax advisors and employment lawyers who will give them a little bit of a freebie to start off with, just to see if there's any work, any further work involved, which they might later charge for, and give them a clue as to what to do in that situation. I hope that answers your question. I'm just looking to see if there's any more questions in the Q&A at the moment. Oh yeah, somebody's asking me, let me see. Yep, so I've got Sharon. Hi, Sharon. Does duration play a part? What extra scrutiny should be applied to an outside IR35 contractor who has been in a role for a few years? So if somebody's deemed to be outside of IR35, then I would say that duration is one thing, Sharon. It is a factor, but the factors that are really important are, what is the relationship between the parties, and can that relationship be challenged? So has the status decision that has been made, is it capable of being challenged by either the individual, HMRC, or the employment rights, the employment tribunal? Is that decision robust? If the decision is robust and the individual is absolutely definitely outside of IR35 and everybody's happy with that, then, I would say that that can continue. And quite rightly too. It should be the case that people can provide services independently. Not everybody on the planet has to be an employee. I do believe in a democratic right to be self-employed, as long as the facts fit what people want it to be. But actually, duration does play a part, because if there is a certain amount of, if there's a certain amount of repetition of a certain role, and there's, a certain amount of control involved, then it could be the case that that status quo could be challenged over time, and the individual, sort of inadvertently becomes part and parcel of the organisation. And it really just depends on how that role evolves. Sometimes people aren't even conscious of the fact that their role has evolved. And for example, they might have taken on management responsibilities or something like that. And unfortunately, that would definitely count against them. So I hope that's okay. I don't have any more questions as far as I'm aware. So I'm going to now just move on to the next slide. Thank you. So if you want any further information or guidance, I think that, I think I may have to do a poll. Yes, I do. Thank you. So if you could leave us a rating for today's webinar, there's a poll on the screen at the moment, hopefully. We do really appreciate your feedback, because it does help us to make sure we're on target with our content and everything. Please take a few moments to respond to it. So having said all of that, we're almost out of time. I'd like to thank you for joining us on today's webinar. Please remember that you can keep up to date with all the latest tax and other professional news, including the latest information, guides and resources on ICAS.com. And looking ahead, we've got a range of events in the weeks ahead which you might want to sign up for. On the 26th of September, which is only a few days away, 2 days away in fact, Making Tax Digital for Income Tax, get your practice ready. On Thursday, you can join my colleague Chris Campbell, who's Head of Tax for OMB, and some HMRC experts are joining him to learn more about how to make tax digital for income tax, how it will impact you and your clients. On the 22nd of October, I'll be back again to guide you through the most significant employment tax cases from the past 12 months. And the session's designed to keep you up to date with the latest developments and trends in employment taxes case law. On the 19th and 20th of November, it's the CA Summit 2024. So the CA Summit is back, and join our award-winning virtual event to connect with the big ideas that are shaping the way you live and work. And in terms of in-person events, there's an event on the 8th of October called Beyond the Numbers. The must-attend conference marks the first opportunity to discover our fascinating research findings into the evolving needs and expectations of society. And it helps us to learn how the profession can adapt to continue serving the public interest. And we'll also hear from BBC radio presenter and author Timandra Harkness for a deep dive into the impact of the technological revolution on the workplace and wider society. So links to sign up to all ICAS events are available on the website at icas.com/events. So it only leaves me to thank you, the audience, for joining the webinar today. I do hope that this webinar has been useful to you. Thanks for joining us, and until next time, goodbye.